Nothing could be further from the truth. In the few instances where this conversation came up, what did General Gotovina say? General Gotovina was discussed this matter with the ECMM as reflected in our brief. And the ECMM monitor who was present during this discussion understood several matters. That the police, civilian police, had control of the situation, and that any person committing crimes should be charged. And next, he took away from that remark that General Gotovina wanted anyone, regardless of whether he was a soldier or a civilian who was engaged in criminal behavior, to be charged with a crime. Remarkably, that is never discussed in the OTP's brief. However, as I refer back to Mr. Golovich, that is exactly what Mr. Golovich did when he came in and testified over the course of the many months where over 1,200 charges were filed on the wake of Operation Storm. As I mentioned at the outset, an item that is conveniently, or whatever reason it happened to be, left out of the prosecution's brief. We need not go into that significantly more than we have, and I refer the Chamber to paragraphs 593 to 599 of our brief to talk about General Gotovina's actions in the face of crime. But fundamentally, we challenge this statement and of Mr. Hederali and the premise of the prosecution, where Mr. Hederali said yesterday most of these crimes were committed by soldiers or by civilians in concert with soldiers. Now, I understand that Your Honor has given us a chart that deals with restrictions of movement in page 148 of the prosecution's brief, and we'll discuss that. But prior to that, we need to discuss the fundamental flaw in the entire analysis by the prosecution. And that is the attempt to designate all of these perpetrators, or most of these perpetrators, as members of the HV. And how do they do that? They do that by throwing the evidence of crimes that have taken place in the Kraina, in Sector South, and we did not debate at one point that crimes actually took place, and then putting it together with units that were located in the area at some time, and a fortiori, because this took place, a crime took place, and units may have been in the area at some point, a fortiori, they were responsible for that crime without ever identifying who the individual perpetrators were. And based on that, they're asking the Chamber to convict the accused. They are simply not anywhere near meeting their burden of proof. This underlying logical flaw was exemplified by all during the testimony of prosecution witness William Hayden, when his conclusory statements and opinions elicited by the prosecution were explored by the defense counsel and the Chambers on cross. And I refer to Mr. Hayden's testimony at page 10,628, line 15, through 10,645, line 7. And without going into this in toto, Mr. President, Your Honors, I'd like to summarize some of that. Mr. Hayden was drawing conclusions about systematic and organized looting and burning by the HV, which upon examination were without foundation. Although he did not personally witness members of the HV involved in such activities, he concluded that the HV committed the crimes because he had not seen civilians in the area. This conclusion was reached by Mr. Hayden despite the fact that one Croatian official, Mr. Pasic, told Mr. Hayden that the crime was caused by civilians taking revenge. Mr. Hayden testified that while he considered the information provided by Mr. Pasic, he ruled out civilians as perpetrators of crimes in the area. He did so despite having no information nor investigation about how many civilians remained in the area after the Serb evacuation. How many civilians came back? This information was absolutely required before drawing his conclusion, as the presiding judge directed to Mr. Hayden at page 10,634, lines 11 to 12. The presiding judge asked Mr. Hayden, I'm not asking you what you saw, and referring to the lack of considering this information. The presiding judge says, I'm asking you whether you agree with me that this is a serious flaw in the reasoning. Mr. Hayden rejected that. Suffice it to say that the prosecution has rejected the same matter. They've done the same exact thing. They have failed to ask, like Mr. Hayden, the following questions, simple questions, before contending that the only reasonable interpretation of the evidence was that HV members, under the effective control of General Gotovina, were the primary cause of crime. Did any of these crimes occur before Operation Storm? Were any civilians returned? Had they returned to the area? When did they return? And how many? Were there civilian police in the area and military police? Did any of these categories of other people contribute to the problem? To the extent that people in uniform were observed? Were they actual soldiers, or do they have access to camouflage information? Were these people acting individually or with one another, or were they acting in an organized fashion as a unit with a command and control structure? This is a fatal flaw in the presentation that is made by the prosecution. If we turn to paragraph 479 of the prosecution's briefs, they argue that the vast majority of these crimes were carried out by HV soldiers, consistent with what Mr. Hyderali said yesterday, that most of these crimes. Well, what does that mean? The vast majority of them were made. Most of these crimes were committed by the HV. The prosecution conceded yesterday, for the first time at page 57, lines 13 through 15, that, quote, civilians were involved in the commission of crimes. Okay. How many instances were they involved with? And when? And where? The prosecution never tells us. Turning back to paragraph 479 of the prosecution's brief, where they note that a vast majority of these crimes were committed by the HV, they make several assumptions. They note that there was no mass return of Croat DPs until August 15th. Now let's look at the logic of that. If there was no mass return, how many civilians or IDPs came back? How many civilians were in the area? Why would a mass return be required for crimes to be committed to civilians? How many returnees or criminals need to infiltrate the area before the prosecution would consider the possibility that they have committed a crime? In pegging this return to August 15th, what they are trying to say is that there are no civilians coming in prior to the 15th, ergo, these are all HV soldiers, and that General Gotovina must be responsible. I hasten to correct their errors in that regard. As shown by page 6 of Exhibit P352, page 2, page 6 of P352, page 2 of D277, and page 1 of P805, and we detail this in our brief at paragraphs 482 and 498. Civilians were coming back to this liberated area as early as the 6th of August. Internationals on various different levels report people coming back as of that date. This is essentially ignored by the prosecution. Next, in that same allegation, they note that the military, and I'm talking about in their paragraph of 479, that the military had full control of the area and checkpoints were established to prevent civilians from entering. Well, we detail this in paragraphs 464 to 469. But their own evidence contradicts that allegation. Look at the citations, as Mr. Teager invited us to do, for that statement. It's Mr. Morich and Mr. Sipsey, and both say that the restriction of movement in the area was done by civilians, the civilian police, not by the military police. Finally, the implicit reference in there that with checkpoints this area is going to be safeguarded and sealed off is simply preposterous. As we see in paragraph 517 of the Gotovina brief, criminals like Billich were getting around checkpoints easily because they knew the area. Mr. Golovich noted that it was impossible to have a checkpoint close off this area. General Cross, who had experience with this in many different theaters, said checkpoints in an area such as this would be impossible to foreclose people from getting in. In fact, there are even reports in this that we can detail where UNMOs, when faced with checkpoints, knew enough about the area to get around it. There is simply no basis in fact for this allegation that somehow checkpoints foreclose people from coming into the area. Finally, of course, what the prosecution tacitly agreed to is that after the 15th, there was a combination of civilians in there and that they were participating in this crime. But their answer to that is, and they cite the chamber to paragraph 195 of the Mardich appeal, was it really doesn't make a difference because they're part and parcel of the working with the Army and they're all guilty and Mardich says so. Simply not true. A completely inaccurate cite which Your Honors directed us to. First of all, if we look at that in paragraph 195, the analysis was that the trial chamber found that these individuals that were committing these crimes were paramilitaries working in conjunction with the JNA and could be directly tied to the accused, Mr. Mardich, as part of his JCE liability. Such facts were never demonstrated here. The evidence that we have is that this criminal activity was disorganized, took place at various times and places with people in uniforms operating in conjunction with civilians. The more appropriate analysis, I submit to Your Honors, is in paragraph